Welcome back to the Friday 5 for September 20th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. On Fridays, we look at 5 questions from the week. We try to answer them in about 5 minutes. Some quick questions, some quick answers. Maybe these are things you've wondered about in the past as well. Question number 1 this week, can I reinstate my dissolved LLC? So in this case, the caller was looking to reinstate a dissolved LLC in the state of New York. And the process in most states is similar to New York. And the first thing we have to do is figure out, why was the LLC dissolved? So if the LLC was dissolved because you failed to pay taxes or other fees, then in order to reinstate your LLC, the state will usually require you to pay those taxes or fees before the company can be reinstated. In this case, however, all the taxes had been paid, there were no fees outstanding, and actually the LLC had just been dissolved voluntarily a few months ago, and the caller wanted to reinstate the LLC to be able to continue the business financing and some other financial issues. In these situations, when you call the state, you'll likely find that without any back taxes or anything else fee-wise that's due, you can easily reinstate the LLC. Now, there may be a fee involved, but it'll depend upon your state and what they want you to do to reinstate the LLC. But generally, we can reinstate a dissolved LLC. It's just a matter of what steps we have to take to do it, and that will depend upon the situation in which the LLC was dissolved. Question number 2 this week, also from that same caller. Even after reinstating the LLC, he wanted to know, can he change the name of his LLC? So again, this will be state specific. We have to check on the state where you're located. And usually there's going to be 2 options when it comes to changing the name of your company. Number 1, you can formally change the name with your Department of State. So in this case with New York, we can actually file an amendment to our Articles of Organization, and we can change the name of the company directly with the Secretary of State Business Division Office, and you can change it that way. And option number 2 that is available in most states is you can do a DBA, a doing business as, or an assumed name, which means you're keeping the original name of your company or your LLC, and you're actually adding another name to the business so that you can say you're Andrew Ayers doing business as Best Law Firm in the World, LLC. So many companies will use this DBA if they have a holding company and they're going to have other lines of business and they want to have a DBA for each line of business. So we have different names, usually for marketing purposes. Question 3 this week, does my LLC need an operating agreement? And this is one of the most common questions I get from anybody setting up an LLC. And it's a classic question with an answer of, depending upon your state, yes. So if you're in a state like New York, you have to have an LLC operating agreement within 90 days of forming the LLC. However, in many other states, you don't have to have a specific operating agreement signed by the members of the LLC. And what happens in those states is that instead of having a written LLC operating agreement, you're just operating your business under the laws and regulations of the state where it is formed. Now, this may sound fine to you. However, if there's any dispute amongst members, if we have other problems, that means there's no operating agreement to refer to. And to settle these disputes, you'll usually have to go to court with a dissolution action. My office is not filled, but my office has plenty of cases right now of business partners who were friends when they started. They're no longer friends, and now we're stuck with dissolution lawsuits because they have no operating agreement, and we need to figure out how to break up the business and break these disputes between the owners. It's much more expensive to go the litigation route than simply preparing an LLC operating agreement when you form your company. Question 4 this week, do I need to update my will or draft a whole new will? Again, this is a very common question I get. The caller has a will from 2018. The will has a lot of provisions that are no longer relevant. So, for example, somebody had passed away who was going to inherit money. The children are no longer under the age of 18. We don't need a testamentary trust for them to hold money until they become 18 years old. And so the question was, do we need to just make changes to the will or start fresh and do a whole new will? And that's purely going to be up to you and your preference. And a lot of times I find it depends on your experience with your estate planning attorney when you first drafted the will. So people who had good experiences with their attorney when they drafted the will normally just say, let's just do a fresh new will. It's easy to do. I've done it before. People who had a rough time with their prior attorney, maybe they had some disputes about what should be in there. Maybe they signed documents they didn't necessarily understand. In that case, they're not really sure they want to go through that process again. And it also goes to the importance of really understanding your attorney and making sure you can work well together. So there's no blanket answer of whether you should update your will or draft a whole new one. It's really going to be your personal preference. It could also be financial. So if you speak to an attorney, it may cost less to just do an update than it would to draft a whole new will. But it's important that you have that discussion with your attorney so you can figure out which of these two roads you need to take. And question 5 this week, do I need a trust for my house, or will a TOD, a transfer on death deed, suffice? So in Minnesota, and actually now in New York as of August 1st, we have a device called a transfer on death deed, which allows you to transfer property at the time of your death to somebody else. It's almost like a beneficiary designation like we use on retirement accounts and life insurance policies. It's not available in all states in the U.S., but in states that have it, it's a way for us to take real estate and have it passed to somebody without having to go through the probate court. And so the question in this case was, do we need to use a trust, meaning we put the house into a trust now, or do we just use a TOD deed? And again, this is where it's important to work with your attorney and understand what are the pros and cons. In this particular situation with the caller, the transfer on death deed would accomplish what the property owner wanted to have happen and is significantly cheaper than creating a trust, moving the property into the trust so that it can be managed and distributed after the party had passed away. And, the interesting thing is what they wanted the trust to say is the same thing that the TOD deed would say. So in that case, you're looking at really an economic decision. You can always create the trust. It'll give you more options. You can put other assets in there down the road. But if you're really limited to just that property and you want to make sure it's just distributed in that way that you can do with a TOD deed, if it's available in your state, it's a good mechanism for you to consider. So that's it. Those are our 5 questions for the week. If you like this video, you can hit the like or the thumbs up button below. You can subscribe to future episodes over on YouTube. There'll be a link below where you can submit questions for a future episode. And you can always go to my website, 𝙃𝙀𝙍𝙀𝙀. We can set up a legal strategy session and go through these questions or other questions you may have. Wherever you are, I hope you have a wonderful weekend.